I'm looking forward to talking with you all about the new reproductive healthcare rules that were recently implemented by HHS and OCR. So, just a little bit of background about why we are even here today. These are new rules that have a compliance date of December 23rd. And the purpose of these was really to protect the access and privacy of reproductive health care records after the Supreme Court's decision in Dobbs versus Jackson's Women's Health Organization. And this also follows an executive order from President Biden directing HHS to take better action to protect reproductive health care information. Let's do some fast facts here and then dive in. This broadly restricts covered entities and business associates from using or disclosing protected health information about reproductive health care for criminal, civil, or administrative investigations, or to impose liability when the reproductive health care was lawful. It also prohibits the use of this information for identifying any person for the purpose of conducting such investigation or imposing liability. And it also prohibits covered entities and business associates from disclosing protected health information to law enforcement unless it is required by law. It also requires covered entities and business associates to obtain attestations under certain circumstances that we will talk about, and it preempts certain state laws requiring disclosure of protected health information. So covered entities, in particular hospitals and health systems, federally qualified health centers, are really going to need to look at all their reporting requirements to ensure that there are no preemption issues. Again, the compliance date for this is December 23rd, so right around the corner, and the effective date was June 25th, 2024. Again, we'll dig into the details, but I just want to give some examples here to set the stage. So what would this prohibit? This would prohibit law enforcement, the production of reproductive health care records related to law enforcement investigations, third-party investigations, and furtherance of a civil proceeding or a criminal proceeding related to lawful reproductive health care. It could also prohibit being able to provide reproductive health care records into an investigation as to whether a particular abortion was necessary to save a pregnant person's life, as this would constitute an investigation into the mere act of seeking, obtaining, providing, or facilitating reproductive health care. And it also could cause an issue if there's a request for protected health information that includes reproductive health care records in a civil suit that is brought by a person exercising a private right of action under state law against an individual healthcare provider who facilitated a lawful abortion. A couple of things here. One, all the examples we are using in this presentation today came straight from the final rule. So this is information and guidance from Office for Civil Rights, who is the enforcement arm for HIPAA under HHS. And second, remember, this rule only applies to reproductive health care records, which we will talk about. It does not apply to other records. So, reproductive health care means health care that affects the health of an individual in all matters relating to the reproductive system and to its functions and processes. This is a very, very broad definition, but note that it does not set forth a standard of care. The final rule talks about what that broad definition means. So it can include emergency contraception or preconception screening, management of all types of pregnancy-related conditions, such as a miscarriage, hypertension, gestational diabetes, pregnancy termination, fertility and infertility treatments, anything involving the reproductive system, even outside of pregnancy, such as menopause, perimenopause, endometriosis, and then other types of care and supplies used for anything related to the reproductive system, such as mammography. So when we look at how broad this is, think about your typical record that you have in a hospital or a provider's office. If you have a record from someone's inpatient stay or ER visit, it may have a list of all past medical procedures and surgeries that that person had. What if a hysterectomy is on there? What if birth control is on there? Because it's going to have a list of all prescription drugs to ensure there's no issues with something new that may be prescribed. And so reproductive health care can be very, very broad. And so as much as, at first you think this rule is limited, once we start digging into it, it can have very large implications. The second part of the rule that's important to understand from a definitional standpoint is what is seeking, obtaining, providing, or facilitating reproductive health care. Again, this rule prohibits the disclosure of protected health information about lawful reproductive health care if it's for a prohibited purpose, which is basically to investigate or impose liability for someone that is seeking, obtaining, providing, or facilitating reproductive health care. So all of these things are examples of what that means. So expressing an interest in, having a discussion with your doctor that's maybe caught in the clinical or SOAP notes, clearly performing any type of reproductive healthcare services, even disseminating information about reproductive healthcare services. So you may not be the provider that is actually performing that information, but you are giving them educational information. That could count too. So digging in a little deeper, again, the prohibition, and I feel like I repeat this a lot, but I know at least when I first started learning about this, it took me many, many times to really understand this. But the prohibition prohibits a release of protected health information related to reproductive health care if the purpose is to conduct a criminal, civil, or administrative investigation or impose liability onto any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care, or to identify any person for such purposes. However, this prohibition on disclosure of protected health information only applies to requests for uses and disclosures that are for a prohibited purpose, where the reproductive health care is lawful under the circumstances in which the health care is provided. So if you are a health system that gets a request, a subpoena, for protected health information, this only applies, one, if there's reproductive health care involved, and two, if that reproductive health care is lawful under the circumstances in which it is provided. So how do we know if it's lawful? Well, the final rule has something called the rule of applicability. And reproductive health care will be considered lawful under one of three circumstances. One, it's lawful under the laws of the state in which the health care is provided, under the circumstances in which it is provided. And so this is actually determined by the law of the state and where the healthcare was provided. So if patient A lives in Indiana, but goes to Michigan to seek reproductive health care, it is going to be the laws of Michigan that apply. Two, in addition to being authorized under state law, if the reproductive health care is authorized under federal law, then it is lawful. Or three, if the presumption of lawfulness applies, and we'll talk about what that presumption means. It's the wrong way. So if a healthcare provider receives a request for protected health information that includes information about reproductive health care, if the health care was provided by the covered entity that received the request, the covered entity must determine the lawfulness of that reproductive health care. So they can review all available relevant evidence that they have about whether the health care was lawful under the circumstances in which it was provided. So if the health system gets a subpoena about, and it's requesting protected health information that involves reproductive health care, and the health system provided that reproductive health care, they have to determine it was lawful. If it's lawful, then the prohibition applies. If the healthcare is provided by another person, it is presumed lawful unless the covered entity either has actual knowledge that it was not lawful or factual information supplied by the person requesting the use or disclosure of protected health information that demonstrates by a substantial factual basis that it was not lawful. So how could this happen? If a health system gets a subpoena requesting all records they have in their possession about an individual, they may have records in their possession from another health system, from a federally qualified health center, from a community mental health center, from the primary care physician. They may have all those in their system. If those records include any reproductive health care and they did not provide the reproductive health care, the health system can presume it was lawful, again, unless they have actual knowledge it wasn't, or factual information given by the requester that it wasn't. So if you think about, you have an individual that presents at the ER, the individual talks about surgery they had for endometriosis, a hysterectomy, an ectopic pregnancy. But the health system didn't do that surgery. They just put it in their notes when they were taking the history. If later those records are subpoenaed, they can presume that that healthcare was lawfully provided, again, unless they have actual knowledge it wasn't, or factual information supplied by the requester that it was not. If the covered entity, again, did not provide the reproductive health care, they don't need to make a determination about whether it was lawful or not because they don't have access to the relevant protected health information. They don't need to conduct their own independent review because they may not even have everything to review, and they don't need to research another state's laws. Let's look at a few examples here. So if an investigator requests information from a health plan about reproductive health care provided by a physician, the health plan can assume it was lawful because the health plan did not provide that reproductive health care. However, the health plan can only assume it's lawful unless the health plan has actual knowledge that it was not. So maybe the patient told them it was not, or the investigator supplies information demonstrating a substantial factual basis that it was not lawful. And again, these are examples from the final rule. An affidavit from the complainant that it was not lawful may be a substantial basis. But if the investigator says, hey, we cannot tell you why it was not lawful because either we don't want to jeopardize our investigation or it was based on an anonymous report, that is not a substantial basis. Another example, a hospital in state A receives a subpoena from an investigator in state A about a patient in state A. However, the patient received the reproductive health care in state B. So again, maybe it's an Indiana hospital with an Indiana patient and an Indiana investigator, but the patient received the reproductive health care in Illinois or Michigan. Therefore, the hospital did not provide the health care in question, and the law enforcement has provided no information to the hospital for the hospital to determine that the health care was not lawful. Well, under that circumstance, the hospital can presume that the healthcare was lawful, and the hospital does not have to provide the information to law enforcement unless the hospital receives a valid attestation, if the relevant permission requires one, stating that it was not for a prohibited purpose, or the investigator can overcome the presumption of lawfulness. I want to stop here for a second, though, and say if we know the reproductive health care was unlawful, this prohibition does not apply. If we know the reproductive health care is unlawful, whether it's through actual knowledge, whether it's through information an investigator or a third party gave us, or it's because you as the covered entity provided the health care and you reviewed it and determined it was not lawful, then the prohibition does not apply and the covered entity can produce those records. So an example, an abortion conducted by a medical doctor that has had his or her license revoked and is not authorized to practice medicine under any circumstances. That is going to be unlawful reproductive health care, and therefore the prohibition would not apply. So the prohibition doesn't apply if it's unlawful. And the prohibition also doesn't apply if the protected health information is not for a prohibited purpose. So remember, this rule really just seeks to protect protected health information about reproductive health care when someone is seeking that information just to investigate or impose liability for the mere act of providing reproductive health care or seeking reproductive health care. However, you can still disclose protected health information even about lawful reproductive health care if it is not for a prohibited purpose. So for example, you can release information to a health oversight agency if they're trying to determine that healthcare was actually provided or appropriately billed in a connection with a claim. So also for False Claims Act, patient abuse, substandard medical care. None of those are reasons that implicate a prohibited purpose. And so protected health information could be released in those circumstances. However, you may need an attestation where the requester states it's not for a prohibited purpose, which we'll talk about. So the next part of the rule states that a covered entity or business associate cannot use or disclose protected health information potentially related to reproductive health care for the following purposes without obtaining an attestation: health oversight activities, judicial and administrative proceedings, law enforcement, and coroners and medical examiners. So if you receive a request for any of these purposes, and it's a purpose-based request, you need an attestation. I think of the attestation a little bit like the authorization. There's a whole list of things that it must have in order to be valid. So there must be a description of the information requested that identifies the information in a specific fashion, such as the name of the individual whose PHI is sought, or a description of the class of individuals, the name or class of persons requested to make the use or disclosure, and the name or class of persons that will receive the PHI. So typically you'll have this for maybe just one individual, but the final rule said, there could be a time when the attestation covers all individuals treated by a certain healthcare provider. There must be a clear statement that the use or disclosure is not for a prohibited purpose, and a statement that the person will be subject to criminal penalties if that person knowingly obtains or discloses protected health information in violation of HIPAA. And lastly, signature of the person requesting the PHI and the date and the plain language. So that sounds pretty easy to get an attestation, but the final rule goes into a lot more detail about when you can actually rely on a valid attestation. So one, if you receive an attestation stating that it's not for a prohibited purpose, and you later discover information showing that it was for a prohibited purpose, or there was any other information that was false or misleading in that attestation, you must immediately cease the use or disclosure. If you find out that there was a material misrepresentation, such as it actually is for a prohibited purpose. So let's say it states it wasn't for a prohibited purpose, but later you receive information from an investigator that they are actually investigating a provider just for providing lawful reproductive health care. If you find that out after the fact and you do not stop the disclosure, then this is considered a breach under HIPAA, and you have to notify the individual, HHS, just like you normally would in the case of a breach. Business associates are directly liable for the attestation requirement. So for example, if an EHR company receives a subpoena for records, they must ensure that if it is from law enforcement, they are getting an attestation. And one important thing is the attestation requirement only applies to protected health information potentially related to reproductive health care. So if you are able to redact out all information that is reproductive health care, you do not need to get an attestation. I think the tricky thing here for a lot of hospitals is going to be that the records are so long. They may go back 10 years when someone requests all records, that one, it may be challenging to redact everything out, especially if your EHR does not have a way to do that. And two, given the broad definition of reproductive health care, it may be hard to even know what really was considered reproductive health care at the time. The attestation cannot be combined with any other form and has to be clearly labeled, but the requester can provide additional documentation to support the attestation. We'll talk about that in just a minute here. PHI disclosed pursuant to an attestation is still subject to the minimum necessary requirement unless another exception applies. And if the covered entity provided the healthcare at issue, remember, they have to make a determination that the healthcare was lawful. They cannot rely on an attestation to say it is unlawful because the covered entity has to make their own determination. So if you get an attestation from law enforcement or a health oversight agency, and it says that the reproductive health care was provided unlawfully, but the hospital actually provided that health care and knows that it was lawful, they cannot produce that, right, if it's for a prohibited purpose. However, even if the covered entity did not supply the healthcare, it cannot rely solely on the attestation based on the final rule. If it says it's unlawful, there must be additional information that really show a substantial basis about why that was unlawful, which is why you can attach other information to the attestation. So maybe you'll have an attestation that says it's unlawful and attach that as an affidavit explaining why it's unlawful. Here's some examples from the final rule. So a federal law enforcement official provides an attestation and court-ordered warrant for protected health information involving reproductive health care. The attestation represents the health care was not lawful, but the law enforcement official will not divulge further information because it jeopardizes the investigation. The covered entity receiving the warrant and being investigated actually provided that health care and determined that it was lawful. Well, in that case, the protected health information cannot be disclosed if it's for a prohibited purpose. Another example, same scenario here with a federal law enforcement providing an attestation and a court order. The attestation represents that the healthcare was not lawful, but doesn't have any other information, and the covered entity did not provide the healthcare. In that case, unless we have additional factual information from the person requesting the information, that is not enough information to overcome the presumption of lawfulness. However, if that law enforcement official gave a sworn statement that the protected health information was necessary for an investigation into violation of specific criminal codes, unrelated to just providing reproductive health care, so for example, billing fraud, then that would be enough. So now that we've gone through the main prohibitions, the rule of applicability and the presumption of lawfulness and the attestation requirements, we're going to talk about a few other issues and then leave room for questions. So what we talked about was kind of the main changes that this rule made, which again, the compliance date is December 23rd, but there are a few other things in there that covered entities should know about. Actually, a lot of other things, but we'll cover a few of them. One, for personal representatives, HIPAA was modified so that a covered entity cannot deny personal representative status where it's otherwise permitted by state law just because the personal representative provided or facilitated reproductive health care. So if a husband helped a wife to receive reproductive health care, helped to schedule the appointments and drove her there, facilitate that, a provider can't say, we're not going to treat you as a personal representative just because you helped to facilitate that. However, it's important to know that the covered entity can still elect not to treat an individual as a personal representative if they have a reasonable belief that the individual has been or may be subject to domestic violence, abuse, or neglect, and the personal representative can endanger the individual. Patient authorizations. There's a long discussion about this in the final rule. So a patient authorization can still be relied upon to release protected health information. So individuals still have the right to direct who has access to their protected health information or where it should be released, such as to a consumer health app. If you receive an authorization, you can release the protected health information even to law enforcement. However, there could be liability if you know that there's material information in that authorization that is false. So for example, if the purpose of the attestation says that it is for use for continuity of care or for an attorney in a divorce proceeding, but you actually know that it's to investigate lawful reproductive health care, and just for someone that has obtained that, that could be a false purpose and misleading, and you can't rely on that authorization. Another really significant issue for all covered entities, including hospitals across the country, is the preemption of state law. So the final rule made it very clear that this prohibition on disclosure of lawful reproductive health care information for a prohibited purpose preempts state law that requires a regulated entity to disclose PHI in response to a court order for a prohibited purpose. So the state law may require the covered entity to disclose it to law enforcement in furtherance of investigation into someone who provided or received a lawful abortion, and the final rule may prohibit that disclosure. And in that case, that final rule, federal law, the privacy rule, is going to preempt that disclosure. However, there is a long discussion in the final rule that the final rule does not preempt laws that require the use of protected health information for other activities. So it does not prohibit reporting for public health activities. And there's a lot of clarity in the final rule about what those are. Investigations of sexual assault, human trafficking, professional misconduct, or licensing inquiries. And I will add with a caveat, so long as those licensing inquiries are not an investigation into providing lawful reproductive health care. Similarly, there may be some mandatory reporting laws that require a covered entity to determine whether the request for protected health information is for a prohibited purpose. Again, reporting of protected health information to public health authorities for public health purposes is not prohibited. And there was clarity in the final rule about what public health includes, which is public health surveillance, investigation and intervention, including identifying, monitoring, preventing, or mitigating ongoing or prospective threats to the health or safety of a population. Let's talk about a new general requirement that's broader than just reproductive health care. So we mentioned this at the very beginning of the session. But if there is an administrative request from law enforcement for protected health information, including an administrative subpoena or summons, or a civil or an authorized investigative demand, it must be required by law. And so you just need to make sure that if you receive a request from law enforcement, you are required by law to respond to that. And then you still have to meet the other requirements of that if it's for a subpoena, such that it's relevant and material to the law enforcement inquiry, it's limited in scope, and de-identified information could not be used. So what are the next steps? One, all regulated entities, covered entities, and business associates should be updating their policies and procedures, their business associate agreements, and the notice of privacy practice. I will note that the notice of privacy practice compliance date is not December 23rd. Regulated or covered entities have a little while longer to update that. I would also definitely watch out for additional HHS guidance. There's a lot of questions here, especially as it relates to preemption of state laws. And so we are hoping for more HHS guidance on various issues and then really train your staff. I can't overemphasize the training. I think this is really, really complicated. I'm getting questions daily that we're having to dig into that raise nuances that are not really addressed in the final rule or are not clear under state law. And so I think training everyone is key, but then also having an internal team that is really going to be the point person when you have requests that can implicate reproductive health care. Now for the fun part. Will this law survive 2025? We don't know. So with the administration change coming, there is an evolving political landscape. And so we do not know what the future of this law is, but we know as of December 23rd, covered entities must comply with it. There is also a case pending in Texas right now where the state of Texas has sued HHS, stating that this final rule is invalid and violates the Administrative Procedure Act and HHS's statutory authority. So there has been no decision on that yet, but we are also watching that and for other potential challenges. Here's some additional resources for everyone, and we can post this PowerPoint too. I will send this to the IRHA to distribute. And if anyone has any questions, I'm available now or happy to take those offline too. So feel free to reach out to me. And my last disclaimer with this presentation, well, with every presentation, but especially this one, please don't take any of this as specific legal advice. This is so fact sensitive that if you do have any questions, I really advise you to go talk with your legal counsel and compliance officers about the application of this law to specific scenarios. Thank you. Happy to take questions.
If anybody has any questions, they can unmute themselves and ask also.
Oh, there is one question. Does this only apply to the female reproductive system? No, I am interpreting this to apply to either female or male reproductive system because the final rule, both the statutory language, and the actual definition and the guidance in the final rule do not limit it to just the female reproductive system.